I'm excited too. This is one of those topics that we never get to talk about, and it's so fascinating. So we do have a lot to get through, Jeff, and I did frame a few questions. Our students are already starting to ask questions in the Q&A in the chat, which I love. And we have an awesome hypothetical, a modern hypothetical for the end of class today. But to kind of tee you up and start you off is, okay, number one, what's the job? What's the role? What's the duties of Congress? And where does Congress get its power to do these jobs? So much of that is going to help us answer, or maybe kind of answer, that hypothetical at the end of class. And is Congress working the way that the founding generations thought it should? Is this their idea and their vision for it, the way it works? Because there's so many fascinating things about the way Congress works. And was it designed that way? And then finally, what are some modern debates and amendments that have changed the way Congress works and its power? So that's really easy to do in 30 minutes. I know you can do it. Let's get started.
Wonderful. So great to see everyone. Hope you had a wonderful Thanksgiving. So just to cut to the end so we know how relevant what we're talking about is, the hypothetical we're going to discuss is, would Congress have the power to impose a national mask mandate? Let's imagine that the Congress passed and the president signed a law requiring you to wear a mask in public. Can they do that? This is extremely relevant because just last week, the Supreme Court issued a very important and hotly divided opinion about whether states could require churches and synagogues to close during the quarantine. And 5 justices said, no, that would violate the First Amendment rights of free exercise of religion. 4 justices strongly disagreed. So that's why the question is so relevant, although the powers of Congress are different than those of the states, and we'll talk about why. The other thing that's really important about Kerry's question is Congress working the way the framers anticipated. I can be confident in answering that question, no. And remember, friends, my job is to be nonpartisan, and whenever there's any strong disagreement among people of different perspectives, then I have to tell you about it. But scholars on all sides agree that Congress was intended by the framers to be the leading branch of government, the most vigorous branch, the one that took the central role in lawmaking. The executive, by contrast, would have a ministerial role, merely executing laws that Congress had passed. A ministerial means not like a religious minister, but like a government minister who would have an administrative role rather than making law himself. And the judiciary would be the least dangerous branch, according to the framers, striking down clearly unconstitutional laws, but generally deferring to the powers of Congress and the states. That's not the way it's turned out. Today, I would think that people would agree that the president is the lawmaking branch. Presidents act by executive orders and issue regulations without consent of Congress because they're often not able to get those orders through a polarized Congress. And the judiciary has become far more active than the framers anticipated in striking down lots of those executive orders, as well as federal and state laws. And Congress is so polarized. In other words, the political parties agree about so little that they're not able to engage in the Madisonian deliberation, the compromise, the discussion that the framers had in mind. We just had such an exciting project at the National Constitution Center called the Constitution Drafting Project. And Kerry, if I can manage to screen share, I'm going to, because you know how much I love to do that. And
let me stop and make sure you have power.
Okay. Give me the power always. The screen sharing power is the only power that I need or want because it's so much fun to be able to share this stuff. So this is all, this was not what I was looking for exactly. This was the podcast that launched the project. And let's see if I can, here's the link to it. So we commissioned 3 leading teams of libertarian, conservative, and progressive scholars to write a constitution from scratch, as if they were in the state of nature. And those of you who've started to follow the law will know that these are some of the most distinguished scholars in America from very different perspectives. All 3 of them, as you'll learn on this podcast, and you can learn by reading their constitutions, it's very clear in the conservative constitution too, agree that Congress is not working the way the framers thought. That Madisonian deliberation is out the window. And that's why all three constitutions proposed ways of reining in executive power, because they thought the president had gotten more powerful than the framers intended, and invigorating Congress's powers to check the president, to engage in oversight, and to exercise the many powers that it's given by the Constitution. So if you want a really interesting exercise, check out this Constitution drafting project, read the three constitutions. They're really helpful introductions to all of them. I'm just writing a short article that'll summarize them, so we can share that with you as soon as it's out. And you can decide for yourself. Okay, that's an introduction, but I hope you see why today's topic is so exciting, because we have to learn about why it was that the framers thought Congress was the most important branch, the most dangerous branch, and how we got to where we are today. All right, now we're going to go to the interactive Constitution, because that's the best place to check out the powers of Congress. And we go to the legislative branch. Kerry, are you still with me? And
yep, we are still looking at it, which is perfect. And I'll give everybody the link to this just in case they want to spend lots of time reading that awesomely long Article 1.
Before we go to the powers of Congress, which are in Article 1, Section 8, and the powers denied to Congress in Article 1, Section 9, and the powers denied to the states in Article 1, Section 10, isn't it clear? It's really well organized. Let's go through the basics. So Civics 101, how does a bill become a law? Article 1 establishes the legislative branch in Congress. Congress is responsible, at least in theory, for making the laws. The Constitution separates Congress into two houses. This is called bicameralism, and that's the House of Representatives, and the representatives are elected under the principle of popular sovereignty. And then there's a Senate, and each state has 2 senators. So today there are 435 members of the House. Representatives have to be 25 years old. They can serve for 2-year terms, and they can run for re-election. And today there are 100 senators, 2 for each state. They have to be at least 30 years old. They serve for 6-year terms, with a third of the Senate elected every 2 years. Do you know that when President-elect Biden was elected to the Senate back in basically around 1970 or so, he was 29. He wasn't actually eligible to take his seat, and he had to wait until his birthday until he could serve in the Senate, because you have to be 30 to be a senator. And he served for many, many years after that. Then Article 1 sets out the powers of Congress in Articles 1, Section 8, and those limits to those powers in Section 9, and then the powers denied to the states. But before we talk about those, let's also remind ourselves, how does a bill become a law? Well, not only through bicameralism, which is that both houses have to pass the law, but presentment. That means that the law has to be presented to the president, who has to sign it. So here's how the process works. Members in either one of the houses, either the House and Senate, can introduce a bill, although spending bills have to start in the House. Then both houses have to pass it by majority vote. There's a committee process. So if a member in the House introduces a bill, then it's sent to a congressional committee that covers the issue, taxes or the environment or education. The committee discusses the bill. If it approves it, it sends to the entire House for debate. The entire House debate and decides whether to pass it or not. If it does pass it, the same process takes place in the Senate. Then, once the bill passes the House and Senate, it's presented to the president. He has 2 options. He can sign it, in which case it becomes a law, or veto it, in which case Congress has the opportunity to override or cancel the president's veto by a 2/3 vote, which is a really high bar. And if the Congress fails to override the veto, then the bill doesn't become a law. And even if it does become a law, then people can go to court and challenge it. So it's really tough to pass a law in the US, but that was for a reason, because the framers were very keen on the idea of thoughtful deliberation, not allowing momentary impulses of passion or emotion to crystallize into law, but forcing you to jump through a lot of hoops before any branch of government could presume to speak in the name of we the people. Okay, Kerry, how's that for an intro? And what questions do you have next?
I think it's fantastic. I think that's the part that sometimes people will look at Congress over time and say it moved too slow or it worked too slow, but that's a part of the process, that there is a deliberative, slow, almost a difficult process put into place. My mother used to say, so Congress wouldn't be fickle. and just push laws through. I know, it was a really good way to
That's
say
great.
it.
That's a great adjective. Fickle is exactly what Congress is not supposed to be. Yes, or impulsive
So
or impetuous.
yeah, and things aren't, if you're going to change the law or you're going to change the Constitution, it's not done quickly. It's not done on a whim. So I think that's really important to know. Can we look through, I'm going to make you go back to the interactive Constitution and think about that final question in hand. What are the powers of Congress, lawmaking, all those pieces? And because I really want to be able to get our students to the end and say, could Congress, may they? And that's really the question. This is not a political question about should they and what they think is what they might be a policy thing to do. But the question is, do they have the constitutional power to mandate a law about the mask? That's the great constitutional question here. So I'd like to say, where are the powers in there that they could pull or not, or the limits that would push back on them to say they could or could not do this?
Great. We're just going to jump right into the hypo. And already everyone is.
I know, he's having a blast in there.
Absolutely. And what all of you in the chat are recognizing is what are the conditions under which we can infer what several of you have called implicit powers. The explicit powers are the ones that we can read in Article 1, Section 8. But I can guarantee without reading it, the word mask does not appear in Article 1, Section 8. So that's not going to be an explicit power. So what about the implicit powers? Let's run through the chat for the first takes on this. Colin asks, what about police power? There's no express policing power in Article 2. Great point, Colin. States have a general police power. The states have a generalized power to protect health, safety, and morals, at least before the Obergefell line of cases, which said that there might be autonomy-based limits on the morals power. But Congress does not have a generalized police power. So we have to find some implicit power that's more explicit than a general police power. But that's a great point. Then what about the general welfare clause? Zia Brandstetter says Congress is responsible for the general welfare of the people, so a mask mandate would fall under that category because it would help curb the immense spike in cases. That's an excellent point, and Zia, and now we have to start getting into some of the case law about the general welfare clause. Under the spending clause, Congress has that's the general explicit power that Congress uses to promote the general welfare. Under the spending clause, Congress has the power to tax and spend to promote the general welfare. So Congress could try to use its power to write a law that gets states to adopt a mask mandate through a combination of carrots and sticks. In other words, if you pass this mask money, you'll get this new, if you pass a mask mandate, you'll get new money. If you don't, we'll take away your money. The Supreme Court has traditionally read Congress's spending power broadly, but it has cut back on it a bit in recent cases, emphasizing that Congress's spending goals have to be related to the general welfare. Congress has to set clear conditions for the states, in other words, the type of mandates that the states will pass and what will happen if they do or don't pass it. And the conditions can't otherwise conflict with the Constitution. For example, it can't violate any rights-based protection like those enshrined in the Bill of Rights, and the conditions can't be too coercive. In other words, Congress can't really force the states to do something they don't want to do. The key Supreme Court language is the conditions must not be so coercive as to pass the point in which pressure turns to compulsion. Hard to know exactly what that point is, but Congress is saying you can have a carrot, but you can't, have a literal mandate. So in other words, if you pass the if you require masks, you'll get these highway funds. That might be okay, but unless you pass these funds, then you will lose all support under the Affordable Care Act. No, that would be coercive. Interestingly, our conservative constitution on the Constitution drafting project wanted to rein back Congress's power to use its spending power in the general welfare because they thought it was too coercive and a front against federalism. So that's a sort of disputed question on the Supreme Court now. But the general welfare clause as a support for the spending clause would be one really strong implicit power. What's the next really strong implicit power that we can find in Article 1? And now I'm going to go back to the chat and see if I can
There's
find
a
it.
lot of good ones in here. So,
well, there's a lot of talk about the commerce power. So let's talk about that. And there's also you've also flagged the necessary and proper clause in Section 8. And Joshua Ascanzi says, regarding the mask issue, I think the necessary and proper clause in Article 8 affords Congress the authority to institute a mask law. In the preamble, the Constitution states one of its purposes is to promote the general welfare. Exactly. So, you know what? Let's take up the necessary and proper clause and then the commerce clause, because the necessary and proper clause is more is broader, perhaps. Let's talk about the necessary and proper clause. This has generally been read as a way of reinforcing other constitutional powers rather than an independent source of power in its own right. In other words, it builds on other enumerated powers like the commerce power. So Congress would still need to find another constitutional hook like the commerce power. And the key necessary and proper clause language is the McCulloch, Maryland case, where the Marshall Court upheld the constitutionality of the second bank, and also cases like Gibbons and Ogden, which address the scope of national power over commerce. And there were other pivotal debates in that period about internal improvements like the creation of a national road system, federal power in the territories, including the right to ban slavery, and more generally, Congress's power to regulate slavery. Broadly, while the Marshall Court confirmed that the Constitution created a Congress with limited powers, it often read those in a way that recognized an important role for Congress in regulating commerce and promoting the growth of the national economy. And I'm trying to see if I can quickly find the language, the end be legitimate, which is from, there we go, it's from McCulloch and Maryland. And here we go. The language is, let the end be legitimate. Let it be within the scope of the Constitution. Oh, wait, no, I just lost it because of that excellent. Let the end be legitimate. Let it be within the scope of the Constitution and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consistent with the letter and spirit of the Constitution are constitutional. So in other words, the court is supporting its ruling under the Commerce Clause by invoking the necessary and proper clause, and says that Congress can, as long as it's exercising an enumerated power, it can exercise that to reach objectives that are not forbidden by the Constitution. So it's interpreting the necessary and proper clause liberally and rejecting Maryland's narrow interpretation to say, Maryland says necessary means Congress can only pass laws that are essential in the execution of its enumerated powers. The court rejects that argument on the grounds that many enumerated powers would be useless if you can only pass essential laws. And that's why Marshall says, if the end is legitimate and all means which are appropriate and which are not prohibited, but consistent with the letter and spirit are constitutional. So it's not a requirement of essentialness, but appropriateness and plainly adapted. And that principle had been established by Alexander Hamilton when he said, if the end be clearly comprehended within any of the specified powers, and if the measure have an obvious relation to that end, and is not forbidden by any particular provision of the Constitution, it may safely be deemed to come within the compass of national authority. And that is Hamilton. So this is a contested view. Today, our libertarian Constitution, which you can find at the Constitution Drafting Power, thought that the necessary and proper clause was interpreted too sweepingly. It was known as the sweeping clause, and they wanted to put the words "and we mean it" after every single power, and essentially require that the enumerated powers be interpreted strictly, and only the exercise which was essential to them be appropriate, not that was not plainly prohibited. You see, it's a question of how sweepingly you're going to interpret the enumerated powers. And that is why the debate over the scope of the necessary and proper clause is so appropriate, and why our constitutions disagree about it. That brings us to the third implicit power that several of you identified, and that is the commerce power. And I'll talk about that in a second. But before I do, Kerry, I'm going to come up for breath.
Yeah.
What do you think?
I think it's great. And I know commerce clause is a little bit of a stretch, but I thought you could also share Wickard v. Filburn to talk about how sometimes something that happens inside of a state can be considered something that affects commerce across states. Like, what if I used to go to New Jersey all the time to go to concerts, and now I'm not crossing the state line to spend money in another state because of a ban that's happening? So I'm just throwing it out there to give you kind of constitutional legs to give this one a little bit more meat, even though we know it's a weak direction.
Wonderful. Well, Wickard and Filburn is a great case to ask about, Kerry, because as you know, that represents the high watermark of sweeping interpretation of the commerce power. And we know that Congress has the power to regulate interstate commerce. And the question is how broadly we should interpret the idea of interstate commerce. So Wickard broadly, it's the New Deal, and there's a farmer who's growing wheat in his backyard to eat it. He's making delicious apple cakes or banana bread or whatever he's making with his wheat. And he's fined under a federal law passed by Congress, which prohibits more than a certain amount of wheat to be grown. And he says, you can't do that, Congress. I'm not selling this wheat. I'm not engaging in commerce with it. I'm just using it myself. And the government argued successfully before the Supreme Court, yes, but Mr. Farmer, if you grow your own wheat, you might buy less of it at the corner store. And that could have a minuscule, but nevertheless meaningful impact on interstate commerce, because if you buy less wheat at the corner store, then your corner store might buy less wheat to sell from a nearby state. And therefore, although the effect is really attenuated, it's enough to allow the regulation. Now, libertarian conservatives, led by a scholar called Randy Barnett at Georgetown Law School, say that Wickard v. Filburn was much too expansive in interpretation of the commerce power, and that the court should have struck down that New Deal era law because there was no real impact on interstate commerce. And Barnett would resurrect a requirement that existed in the pre-New Deal jurisprudence that you could regulate manufacturing of a product, but not its attenuated effects. So this would essentially not allow the court to use production and the indirect effects of a activity to tell whether or not the activity has an effect on interstate commerce. The Wickard case said this, whether the subject of regulation was production, consumption, or marketing wasn't important, as Congress could reach activities that were local in nature if they exerted a substantial economic effect on interstate commerce. And this overturned the cases which had said that Congress has the power to ban the shipment in interstate commerce of, for example, lumber manufactured by employees whose wages are lower than the minimum wage, and it could also reach the employment of workers in the production of goods produced for interstate commerce in violation of the wage and hour laws. But although you could regulate the manufacture or the production of goods, the earlier holding in a case called Schechter Poultry, which struck down a part of the New Deal, that's the so-called sick chickens case, because it involves the regulation of sick poultry. The Schechter case had said you need such a close and substantial relation to interstate commerce that their control is essential or appropriate to protect commerce from the burdens and obstructions. Don't you see we're using the same debate in the necessary and proper clause? The question was, is the conduct essential? And here again in the commerce case, the question is, does the effect on interstate commerce have to be essential, or the control of the activity has to be essential to protect commerce from burdens? Or does there just have to be some economic effect, maybe a substantial one or an even more attenuated one? So this is the very nature of the debate. Until the Affordable Care Act case decided around 2013, I would have said that Wickard v. Filburn was uncontroversially the law. Randy Barnett tried to persuade the Supreme Court to overturn it not too long ago in a case called Gonzalez against Raich, involving medical marijuana. And the Gonzalez and Raich case was decided in 2005, and that ruled that under the Commerce Clause of the Constitution, Congress may criminalize the production and use of homegrown marijuana, even if state law allows it to be used for medicinal purposes. And it was a lopsided decision, not a 5-4 decision. And the court broadly rejected Randy Barnett's effort to overturn Wickard and Filburn. It was a 6-3 case. Justice Stevens, a liberal justice, was joined by Justices Kennedy, Ginsburg, Souter, and Breyer, and the late Justice Scalia wrote a concurring opinion. So it wasn't really considered a close case. And this idea that you could regulate even a homegrown product because it had an indirect effect on interstate commerce was upheld. But then the Affordable Care Act case came about, and we're not going to review the whole thing, but 5 justices, including Chief Justice Roberts, held that the mandate of the Affordable Care Act, which says that unless you buy health insurance, you have to pay a fine, could not be justified under the Commerce Clause because it was a form of economic inactivity rather than an economic activity. And Congress couldn't regulate economic inactivity, like the decision not to buy health insurance, any more than it could regulate the decision not to buy broccoli or health club memberships, that basically the decision not to do something wasn't regulable by Congress under its commerce power. With that in mind, now that you know that the court has held that the Commerce Clause does not reach economic inactivity rather than activity, but that it has not overturned the Wickard case, which says that economic activity that has an indirect effect on interstate commerce can be regulated, now you're as well positioned as anyone could be to decide whether Congress has the power to pass a mask mandate under the Commerce Clause, supported by the Necessary and Proper Clause. Okay, this is your...
So you're asking them not only if Congress can, but if the answer yes, they almost have to give the evidence of where the power is. That's like an awesomely hard question, but I love it.
Well, it's the hardest question around. And friends, if you read that religious liberty case from last week, and I would like you to read it because it's the most... First of all, it's the first important decision that Justice Barrett participated in. It seems that she wrote the unsigned per curiam or by the court opinion. And there are concurring opinions by Justice Gorsuch, which are really important, and very powerful dissenting opinions by Chief Justice Roberts and by Justice Breyer and Sotomayor. And Chief Justice Roberts said, look, we don't have to decide this case. New York has already changed its regulations, so why don't we wait until we have a live case in front of us? And also Chief Justice Roberts defended his liberal colleagues for interpreting the Constitution in good faith. Justice Gorsuch had said the Constitution may take a holiday during the pandemic, but not a sabbatical. And Chief Justice Roberts didn't like that. He also, they disagreed about a case that's so relevant to our mask mandate, Hypo. It's the relevance of the Jacobson case. Jacobson was a case during the smallpox epidemic at the turn of the last century, which mandated vaccinations. And Jacobson, Massachusetts, 1905, upheld the city's decision to require its residents to get a smallpox vaccine. That is, as long as the regulation isn't too great a burden on constitutional rights, maybe like how long the regulation is going to be in place and how many people or things it covers, then states have the power to pass it under the police powers, which Colin had called out earlier in our discussion. And in this really fascinating religious liberty case, Justice Gorsuch takes Chief Justice Roberts to task for having cited Jacobson in earlier COVID cases, and Chief Justice Roberts fired back, I was just citing that for the obvious proposition, in my view, that generally it's up to the political processes to decide emergency health measures. That's all that case said, and we affirm that. So now Jacobson doesn't solve our congressional mask mandate hypo because it involves state police powers. And I'm going to just
Mm.
to cut to the chase and tell you that out of all questions, this one is really hard. We did a podcast on national COVID mandates kind of close to March or April. It was at the very beginning of the epidemic. You can find it in the We the People archives. And our scholars essentially said Congress has never tried to pass a national uh, health mandate during a previous epidemic. So therefore, there's no clear precedent. But I won't tell you which way they were leaning about whether or not it would be constitutional. So why don't you chat your answer based on everything you know now? And we're going to vote yes or no, but let's have a couple comments about if you think it is constitutional under the Commerce power, why, and if not, why not?
And there's a great comment in here that I just wanted to read out loud from a student at the Great Valley School. I believe that it is possible for the federal government to pass a mask mandate, but considering the great political division of citizens and members of Congress, it may not be the smartest idea. And then goes on to talk about there could be civil unrest, and seeing as wearing a mask may not be considered essential, it's likely a mask mandate might not get far in Congress. And I thought that was a really interesting perspective to bring out, almost answering the constitutional and possibly political question in the same answer.
Well, it's an extremely good point to bring out. And what you have expressed, Great Valley School students, is we generally rely on the ordinary checks of the political process to stop Congress from passing stuff that doesn't have broad national support. That's why we prefer elected officials rather than judges to be policymakers, because if something is really unpopular, probably it's not going to get past Congress. And goodness knows, we just saw how hard it is to pass a law in Congress, even before political parties. And now that the parties are so polarized, it's even harder to get a law past Congress. So unless a law has overwhelming support among citizens of both parties, it's unlikely to pass. And as you say, Great Valley School, it's hard to imagine in practice Congress passing a national mask mandate today, because at least it would be among some citizens unpopular. It's become a kind of partisan issue, for better or for worse, and probably it wouldn't get through. So that's why Chief Justice Roberts in the Jacobson case said, ordinarily we trust Congress and the states to balance difficult questions of public health against those of liberty, because we trust the political checks to protect us. But Justice Gorsuch fired back, when it comes to religious liberty, we're not going to trust the political checks. The religious freedom enshrined in the text of the Constitution has to trump any powers that may or may not exist. So that means that we still have to decide, what if Congress were to pass the law? And I agree with you, Great Valley students, it's not likely to pass, because that's why it's a hypothetical. But that's not going to stop us. We students of the Constitution love hypotheticals. Imagine that Congress passed and President Biden, once he's inaugurated, were to sign a national mask mandate. Would Congress have the power under the Commerce Clause and the supporting powers? Ralph, I still believe Congress had, Ralph Vigiano, I believe that Congress has power to pass this under the Commerce Clause. The way I interpreted the Commerce Clause gives the federal government its power to execute this mandate. This probably wouldn't go through well, depending on how strong the executive branch is in terms of executing it. And it should be up to each state. Like medical marijuana, it's a state-by-state decision. But just mentioned, the checks and balances system does what's best for people. So if something's unpopular among a majority of the system, there's no way it could go through. Ralph, you're really reinforcing very well a version of the point that your colleagues made, which is, if it's really unpopular, it's not going to go through. And if it did go through, Congress probably would have the power to pass it. And that's generally been the presumption ever since Wickard, that Congress gets huge deference, even more than the states, because the states might be motivated by factions. There might be partisan desire to suppress liberty, where the majority crushes the minority. But Congress, it's so national, it's so hard to get something through. If a law passes, the presumption had been, we're going to defer. Justice Holmes is the great defender of deference to Congress. And he said the Constitution is made for people of fundamentally differing points of view. It's not a wonderful expression of judicial humility essentially saying it's not up for me as a judge to second guess cases where my fellow citizens disagree. The Constitution is made for people of differing points of view, and generally we rely on Congress to resolve these difficult disputes involving facts and public health, even if we as judges might disagree. So that's the argument in favor of Congress's power to pass the mask mandate. And just to reinforce your point, Ralph, on our podcast, our scholar of the history of quarantine said that she thought that the Gibbons and Ogden case, which upheld broad national power, would be enough to support Congress's commerce power to impose some kind of quarantine, jumping off of various emergency federal laws that have been passed under Congress's health power. So that's the argument in favor. Now let's hear the argument against. Jackson Strassman says the 10th Amendment's been interpreted by the Supreme Court to prevent the federal government from commandeering or requiring state officials to carry out federal directions. This is what prevents Congress from requiring states or local areas to mandate masks. Excellent, Jackson Strassman, and that's exactly right. And this anti-commandeering principle is precisely what you say. So under that line of cases, Congress couldn't say pass the mask mandate or I don't know, you're going to lose a whole lot of federal funding that you'd be otherwise entitled to, like COVID relief, like the PPP program. That would be a clear example of coercion or commandeering. That wouldn't work. But what about a carrot? If you pass the mask mandate, you get extra money. It's not like you lose it if you don't, but you get this COVID thank you fund that, or you're first in the line to get highway funds or some such. So we can imagine a mandate that wasn't quite commandeering, and that's the tricky case.
And there's a lot of comments in here basically about leaving it up to the states, letting the states decide, and federalism. So I think that is the other way of saying Congress shouldn't, and it should be the state's job to pass under the policing powers of the state. Because earlier, one of the questions that came in is how does federalism influence the powers of Congress? I guess the answer would be when to not step in and allow the states to do it.
Absolutely. I mean, the states, I would have said have a general police power that allows them to do it, but this religious liberty case says no, at least when it comes to churches, that unless churches and religious institutions are treated at least as well as other essential businesses, then that may not be the case, although the court wasn't quite clear about exactly how they were going to strike that balance. But Congress's power, to the degree that it exists, is supreme over state power, because the supremacy clause says that federal law is the supreme law of the land. At the Constitutional Convention, Madison wanted to give Congress a veto over state laws. That didn't pass. But if Congress were to pass the mask mandate and it were valid under its commerce or spending or general welfare or necessary and proper powers, then that would trump state laws to the contrary. That we know. Well, we're not going to.
I know we have to wrap up, but I just wanted to point out Emily's really good point. So hypothetically, Congress passes the mandate. Do they then also have to provide every citizen with a mask? Does an inability to have the money to buy those masks then create some kind of barrier to your freedom as well? I thought that was a really, really interesting point from Emily.
That's a great point. Emily. If Congress were to mandate a mask, then it's interesting that there's not a really clear line of cases that says that economic discrimination or laws that have discriminatory effects violate fundamental rights. This is a bit of a interesting sideline, but in the 1960s, the court came close to saying that, for example, raising bus fare might violate, it was called the substantive due process line of equal protection cases. That sounds like a mouthful, but it was basically the equality provisions of the Constitution create a substantive right not to be burdened by laws that fall more heavily on poor people than rich people. But then the courts stepped away from that because it would invalidate most regulations. I mean, taxes have disproportionate impacts on the poor and the rich if they're not progressive taxes, and any increase in municipal services that cost more would be also problematic. So basically, the court stepped away from that. However, if Congress were to actually require the use of masks, I think there'd be a decent case that someone who said that they couldn't afford to buy one could object. And then the question for you, Emily, is what provision of the Constitution would that violate? Would it be a separate provision of the Bill of Rights, or is there something inherent in the commerce power or the spending power that prevents Congress from mandating things that some citizens can't afford? Not an easy question, but you could argue that in different ways. All right, I think we should stop. What a great
I know, this was just fun. I have a million more questions.
Yeah. Here's just what I want to leave you with. As you can tell, there's no clear answer to this question. And if you read the really fascinating debate on the Supreme Court religious liberty decision, you'll see, boy, those justices disagree about COVID restrictions and religious institutions. But as you answer these questions, I always want you to ask not what you think government should do, but what the Constitution allows or forbids. And as you think about what it allows or forbids, really think hard about the arguments on both sides, because these are totally open questions. One thing I hope you took from this discussion is there's no clear answer to this. Congress never tried it before, so the courts have never ruled on it. So don't be overconfident in your answer. Don't say it's clear that Congress does have the power or clear that it doesn't. Express your constitutional conclusions with a sense of humility, of respect for the arguments on the other side. That spirit of liberty is the spirit that's not too sure it is right, said Learned Hand, a great judge. And always remember Justice Holmes, because I think it's an important counsel of humility. The Constitution is made for people of fundamentally differing points of view. All right, that's what I got for today. Great discussion. Kerry, why don't you sign us off?
Thank you all so much. It's really fun. You guys were awesome in the chat. I can see your brains moving a mile a minute. And I love this. I love when we talk about Congress and the powers. We talk about it from 1787 to modern times, and it gets our brain moving. And we can stay tuned in to see what does happen. Colin's point, I think, was very valid. Aren't we all glad that our homework isn't to write this opinion?
Yes,
so,
yes.
That is not work with.
If you want it, if any of you feels like it, if you feel like writing the opinion, I would love to read it, and so would Kerry. So that's extra credit. But
and thank you, Nick. And he is totally right. Thank you, Jeff, for reminding us to be humble in our opinions and think of multiple answers, because everybody usually has a really good perspective they're coming with, and we need to make sure we're listening to that as well. So thank you so much, Jeff, and thank you, everybody in class. This was a really fun Monday.
Thank you, everyone. Bye.
Bye-bye.